Hello and welcome to lesson number 9 of the drafting pleadings and appearances of the new syllabus. So this lesson is on pleadings. For the old syllabus it is lesson number 8. So a majority of these topics we have covered the basics of it in lesson number 1 of the new syllabus, which is on the basics of these concepts. So I will try to improve upon that. Hence, if someone has not referred our video on lesson number 1, so I sincerely suggest you to please go refer lesson number 1 and then start this lesson. So in this lesson we will be covering the topics of plaint and written statement, dilatory pleas, interlocutory application, execution, appeals and revision, complaint, criminal miscellaneous petitions, FIR and bail. So this is the basic coverage of pleadings, and it is quite vital from the examination point of view, for the reason that you are assured to get minimum of at least 4 to 8 marks from this lesson for sure. So if you concentrate like good amount of time on this lesson, there is high likely of chance that you can score good from whatever be the question which is asked in this lesson, right? So without any delay, let's move forward. So pleadings. So what is the meaning of pleadings? So it is very important to know that pleadings mean, as you can see from the name, pleading. You are requesting someone for something. So in a suit, who requests whom for what? A plaintiff requests a judge for a particular relief, correct? And then in response to the plaintiff, what does the defendant do? The defendant also pleads the court, saying that kindly do not listen to that plaintiff. He is wrong. Right, which means both the plaintiff is also pleading the court and the defendant is also pleading the court. Hence, both the plaint as well as the written statement are together referred to as pleadings. So this should be the first and foremost thing in your mind. Like pleadings means plaint and written statement. So that is what is the meaning of pleadings, right? And the objective is to help the court to adjudicate the real issue between the plaintiff and the defendant, right? So these pleadings will help the court. Like just think, if the plaint is not submitted or the written statement is not submitted, how would the court at any point of time know what is the dispute between them before they can adjudicate? So this plaint and the written statement, that is the pleadings, will help the court to understand the dispute, to understand the cause of action, and accordingly to adjudicate the real issue between them, right? And there are 4 basic rules of pleadings which you should remember, and these 4 basic rules would apply equally to the plaint as well as written statement. Number 1, there shall be only statement of facts, not of law, right? So you are only giving the statement of facts. So what does it mean? So in a plaint, you should not try to explain the court the interpretation of any section or the precedent set by any court. That should not be the case unless that is the fact of the particular case. You should not try to give it. The plaint should be as simple as possible. It should try to establish what happened. It should try to give what are the facts, and not all the facts should be there. Only material facts and material facts only, right? So you should not try to say so and so was born on so and so to the parents of so and so, his childhood was all happy, and then he had a job of so and he was earning 80,000 per month in so and so company, and he has got a wife, he has got 2 children. This is not the requirement to describe a plaintiff. Simply his name, son of who and who, what is his age, what is the address, that's all. You getting it? So materiality of a fact is very important. The example I've given you is quite silly and simple, but the reason why I wanted to give that example is for you to understand the metaphor there, that you cannot try to give facts which are vague to the situation or which are vague to the cause of action. You should try to make the facts as material as possible, right? And all such pleadings shall be signed and verified. So what is meant by verified? In pleadings, I will explain you briefly what is the format. So at the end, after the sign the pleading, again there will be something called as verification, wherein they will specify saying that the contents of paragraphs 1 to 30 are true and fair to the best of my knowledge, and I hereby verify the same. So there would be a para on verification, right? So I would hereby verify that the content are accurate, true to the best of my knowledge. So there are different ways of putting it, but that is very important. You should sign and you should also verify that I have read all this content, I have read all this paragraphs, and I have pretty well know this stuff, and that's the reason why I'm filing this plaint or the written statement, right? And the facts shall be such that those are the facts which the party pleading the same relies upon, and it should not be the evidence by which they are to be proved. So at times there is a scope that you don't have evidence to prove something, but you by fact, like, you know that something had happened. So the facts which you rely on is very important. Even if you do not have an evidence to prove at that point of time, in a plaint, you have to mention the facts which you rely on. In a written statement, you have to mention the facts which you rely on, right? So the party pleading, be it the plaintiff or the defendant, they will have to give only the facts on which they rely, but not the evidence. And then finally, whatever be the material facts, they have to be concise, that is with precision and certainty, right? So this is something, these are the 4 basic rules of pleadings. Now, the first pleading, which is the plaint, because this is the initiation of a suit, as we have discussed in detail in lesson number 1. So plaint is filed in order 7 of CPC. So in CPC, we have something called as orders and rules, but so you remember this, that plaint is under order 7. Now, what does the plaint contain? So we know what is a plaint. We have seen in lesson number 1. I've explained you in detail with an example what can be a plaint. So there is a dispute, and aggrieved party who goes and files a case before the court is referred to as a plaintiff. The document through which he is pleading the court is referred to as a plaint. Now, a plaint as a structure, firstly, should contain what? It should contain the name of the court and the case number. So I will try to briefly give a format here. So concentrate. So here it would start like this. It would state, in the court of first additional civil judge, so and so state, so and so district, so and so state. Okay. So that is the name of the court. So here we would write the case number. So it will be in OS number, that is original suit number so and so of 2020, right? So that is what is the name of the court and the case number, right? Now the cause title. So what is meant by cause title? Cause title is nothing but it includes 2. One, so this particular aspect is what is the cause title, that is giving the name of the court and everything, and also the details of the parties, right? So now here we would say, in the court of so and so, in OS number so and so, between, or it would also be in the matter of Mr. A and his description, plaintiff versus Mr. B, his description, defendant. So this is how your plaint starts. This is the starting point, right? So now after the cause title has come, now we have to see the next matter, which is address for service, right? So this is the cause title. This is the address for service, the people whom you are sending it. Now comes the subject matter. So how does the subject matter come? So this is in the page 1. Now, usually either this in the page 1 or in the same page where you get the text, you can write the next one. So now I'll show you how we will see the next steps. So here we will have a heading, plaint under order 7. It's a very standard heading. There will be few headings which will try to indicate what is the plaint about. Suppose plaint for partition, right? Plaint for family partition, or plaint for if suppose there is a injunction which you wanted, so plaint for permanent injunction. So like that, there would be a heading also depending on subject matter, but it's a simple way of writing is plaint under order 7. Now here under that, the first thing we will write is the subject matter. So under the subject matter, more or less, we will firstly write the facts. So we will say who is the plaintiff. Plaintiff has a so and so, is having so and so occupation, he is into so and so. Next, slowly start describing the dispute, what happened, right? So this is the subject matter. Initially you will try to establish what happened before the dispute had happened. Then we get to the cause of action. So in the cause of action, we will try to establish that, okay, because of all these acts of the defendant, I had to come to the court to take the court's protection or to take the court's order for a particular act, right? So that is what is a cause of action. So cause of action plays a very crucial role, and drafting it is very important in the sense that whosoever is the draftsman who is going through the drafting of any cause of action clause, that makes a very crucial role. Your facts and all are also equally important, but the way you establish the cause of action, that plays a very crucial role, right? Then, so this is the most important point. And so once you have given the facts and what is the dispute, there is a cause of action, then you have to establish that this court has got jurisdiction. So there is a separate clause in jurisdiction saying that the property is situated in the state of Maharashtra in so and so district, let us say Nagpur in near Wardha. So now the jurisdiction point, if you go to the court in Wardha, you can try to say that the property is situated here and hence this court has got jurisdiction to entertain any suit against the same. So that's how you have to establish the court saying that, see, you have jurisdiction to take up this case. Then valuation of the suit. Every court or every suit has got some kind of a valuation depending upon the kind of suit it is. So it's called court fee. You have to make certain court fee depending upon what the suit is. So accordingly, you will say that this is the valuation of the suit is of so and so, and hence the court fee applicable is so and so, and the same has been duly paid by the receipt number so and so. So like that, it's a basic establishment saying that now the case is valid because there is a possibility of a preliminary submission by the other party. So what is a preliminary submission? A submission made right at the initial stages of a suit without even going into the merits, wherein we will try to say that, see, the valuation has not been done properly or the court fee has not been paid properly. These are certain glitches. And because of this glitch, the court cannot entertain your suit also. There is a risk that the court can even cancel the suit, right? And hence the valuation also plays a very important role as good as the court fee. So then finally we will have the prayer clause. So the prayer clause where we plead as to what we want, right? So that is the prayer clause. In the same way, that's also called as the claim or the relief. So what do you want from the suit, right? And then verification. So this is again a clause. So after all the prayer clause, there will be a signature either of the defendant or of the plaintiff. They will sign. So since it's a plaint, sorry, it is of the plaintiff. So the plaintiff will sign here. And again, after signing, there will be a heading like this in the middle of the page, right at the bottom, verification. So here the plaintiff will say, I, so and so, hereby verify that the paras 1 to so and so of the plaint are read to me or drafted by my counsel, or you can say that I am very much aware of paras 1 to 2020 so and so, and out of my own will I am filing this suit, something like that. So it's basically trying to verify the content, that yes, I know what is there in the content, I have read all the content, and only then I have signed, right? So that is a verification clause. And then all the list of documents which you are enclosing along with the plaint. Suppose you're saying I'm the owner of so and so, then enclose the title document. So everything will be enclosed along with the plaint. Right? At times there is no need for you to even give title deeds and all, but few documents which you feel are relevant to be enclosed along with the plaint, you can do that. So this is a plaint, and this is how a plaint is drafted, right? Chalo, let's see how a written statement is drafted now. A written statement per se is made under order 8. So rest of the facts being very clear to you, remember a written statement should contain the following, right? The format is still the same. You remember the one which I drew there, in the court of, in OS number, in the matter of Mr. A versus Mr. B, and then written statement under order 8, or you can say written statement to the plaint filed by Mr. A, something would be the heading, right? And then in your first point, there will be certain submissions you can make, right? So there is two ways of doing it. First, you should always try to produce the denial. And second, you should try to give additional statement. If you want to provide anything in addition to what the court has to know, which is apart from the reply to the plaint, you can do it there, right? So here, first para would be, you can have the heading as reply to the plaint. So here usually they will write a heading like this, para-wise reply to the plaint, that will be the heading. And then first point, like in reply to para 1 of the plaint, the defendant hereby contends that so and so, so and so, so and so. So here bits, the reason why I'm telling you this is that it's very important to deny every single point if you feel that is not correct, and failure to deny is deemed as an acceptance. So that is a very huge risk. When you're drafting a written statement, it is very important to contend every single point. But where you agree on something, you should agree, and where you have to deny, you have to deny. You cannot remain silent on any point. If you remain silent, that will be taken against you. So that is a risk, and you have to keep it in your mind, right? So denials, dilatory pleas, we will see in the next point. Then objections to the point of law. So in case there is any objection raised to the point of law, in terms of, say, in the plaint they have mentioned something on law, saying that, let us say a simple case I can tell you, a shareholder where the transfer is there. So they tend to say that a share transfer deed has been executed but has not been transferred, right? So now you can contend on the point of law saying that, see, the limitation period has been done, it has been signed long back, and I did not get the consideration also. That is the very reason why I'm not transferring the share. So some point of law, if you want to object, even that can be made. Any special defenses can be taken, and any set off or counterclaims can also be made. So what is the set off or counterclaim? Suppose in the plaint he says that Mr. B owes me 10 lakh. In your written statement, you can make a set off saying that, see, I have given him 3 lakh. So kindly set this off, and balance the amount shall only be 7 lakhs. So 3 lakhs has already been paid by me long back through some other means, which he is not considering for this loan. Hence, I want this to be written off, this amount to be written off from that, set off from that, and the balance will be payable by me. What is the counterclaim? Where you say, I have paid him 13 lakhs. So in fact, that fellow owes me 3 lakhs. So this is a counterclaim, right? So this is how we draft a written statement. It's the thumb rule of written statement is the format remaining the same. A reply to each and every para of the plaint. That is a thumb rule. Now, so what is a dilatory plea? So dilatory pleas are those which we try to, which tries to delay the trial of a suit on merits. So what are merits? So merits means the facts of the case. So even before we go into the facts, as I told you, some concept called as preliminary submissions. Dilatory plea is one such thing. So where the advocate or the other party, instead of arguing on the point of law, instead of arguing on the merits of the case, that is a fact, they literally argue on the point that, see, there are certain things like court fee, okay, and jurisdiction. Jurisdiction is very important thing. Court fee is one important thing, where these two are like very common grounds on which the court would go and, the other party would go and argue or plea before the court, saying that you cannot entertain this case because the court fee has not been paid. So leave about arguments on merits. Merits can be anything. Even before I go into the merits, sir, you cannot take up this case. You are not competent enough to take up the case. Second, sir, you cannot take because the valuation as court fee has not been paid. Right. Third, where locus standi. So there is no locus standi of the other party, where you try to establish saying that this fellow has no locus standi to file this case. He is not competent enough to file this case. Where is the board resolution? Where did the company authorize him? Let us say a director of a company has filed for a suit. So show me the authorization where he is authorized to file the suit. So like that, there are various tactics by which we try to delay the proper trial of the suit, right? So that is what is called as dilatory pleas, right? And hence, and also since these are preliminary submissions, it has to be raised right at the opportunity possible. You cannot tend to delay it at any point of time, okay? It has to be raised at the proper time possible, that is the earliest possible time, right? So that's why we call it as preliminary submissions, which are submitted at the earliest stage, right? Chalo. So now let us look at what are interlocutory proceedings. Even this we had a fair amount of discussion during the first session, during the first lesson. So now what are interlocutory proceedings? Interlocutory proceedings are of predominantly of this supplementary proceedings which are provided under section 95. Of course 75 also comes, which are incidental proceedings. So I will talk about 75 at the end, but let us firstly see what this 95 supplementary proceedings are. So interlocutory proceedings are those proceedings which are during a particular time, that is after a suit is being filed and before the suit is being disposed. So any proceeding which happens during this period of time is called as interlocutory proceeding, and I don't mean that proceeding in the main suit. So any interim order you want, for which you make a separate application, that is called as an interlocutory application, and it's an interlocutory proceeding. The proceeding being held to dispose of the application is called as interlocutory proceeding. A very common example I always give is, let us say A owns land, B is occupied it. So A has filed a suit against B saying that B has unauthorizedly entered into the possession of A's property. So now there might be a lot of time taken to dispose of the suit. Firstly, they will see whether A has title or not. B will produce document saying I also have title. So then the fight between A and B, fight between the advocates of A and B. After all that drama, there would be that point when A would ask B saying that, or rather A would ask the court saying that, see, if B is allowed to continue being in possession of my property, he would put it to wrong use and put it to full use, and he would be benefited, and that would put me to detrimental loss, right? So that way A immediately needs a relief which is not allowing B to enter this land, neither will A enter this land. So what happens then? A will file a interlocutory application under section 95 pleading for temporary injunction till the date of or till further orders. So then the court will listen to the plaintiff in a separate proceeding called as interlocutory proceeding. That has nothing to do with the main proceeding. That will not have a plain written statement, nothing, but it will have a application. So there we'll call it an application, interlocutory application, and this application can be filed either by the plaintiff or by the defendant. Defendant also can file applications at times. Okay. So now when both plaintiff and application file application, then you have to give a time for the other party to counter your application. So we call it as counter. In such a case, the other party's document is called as counter. It is not called as written statement, or it's not called as written statement. Fine. So it will be by way of an affidavit. That's why they call it as counter affidavit. So now, some theory that this is basically fundamentally the concept of interlocutory proceedings. So some theory is like, after the suit is instituted and before it is finally disposed of, the court may make interlocutory orders. So firstly, filing of interlocutory application, then there will be interlocutory proceedings, then interlocutory order will be passed by the court. It is also called as interim order. And the power to pass or grant interlocutory orders can be traced back to section 94 of the CPC, where section 94 summarizes general powers in regard to various types of interlocutory orders. That is, see, only those orders which has been specified under the CPC can be obtained. Right? Now, similarly, now if you see what is section 75. So power of court to issue commissions. So what is commission? So basically commissions is like issuing, let us say the court needs the help of an expert to look into the case. The court needs some local commissioner to listen on a particular issue, right? So this way it would be a parallel proceeding, but on a focused area of, it's a non-focused area which is very quite incidental to the main suit, but it is not part of the main suit. It is not the trial. So that is what is a incidental proceeding, which is dealt with under section 75. Okay. Right. So application for execution. So in lesson number 1, we have seen the difference between a decree and judgment. So judgment contains facts, cause of action, issues framed, arguments, rationale behind the judgment, and then finally judgment. So this is what the judgment finally contains. So leaving all this, the judgment in the sense that the final executory portion will be reproduced in a single page of sheet that is called as a decree. So after a decree has been pronounced, after judgment has been pronounced and signed, there will be one more sheet called as a decree that will not contain the facts, that will not contain anything. It will only contain the cause title, that is the description of the court, the description of the case number, then the description of the parties, and then the order. So that is the decree. It says the decree, the final executory portion. So decree is the executory portion. What is the ascertainment of the rights and liabilities of the parties? Only that will be contained in the decree. Now, what is the concept of execution? So suppose a decree says A shall pay rupees 10 lakhs as compensation to B. Now A did not pay it. So court, let us say court has given 3 months of time to pay. 3 months have expired and A did not pay. Then B will go to the court and file a petition called as execution petition. It's also called as application for execution and popularly called as EP, execution petition, wherein we will specify the number of the suit, that is the case number, the primary case number, then the name of the parties, the date of the decree when it has been passed, if they have appealed, if the other party has appealed or not, right, and the description of the order, the what has been the decree, what has been passed in the decree, the details of the judge who has passed the decree, and the timeline given in that as part of the decree. So all of this shall be clearly specified, along with whether you have made any communication to the other party to get the amount of payment from A. So all of this will be specified in the petition, that is the application for execution, and such application shall be in writing. It shall be signed and verified by the applicant, and it should be provided to the satisfaction of the court as to the court has to be satisfied that okay, there is a order. So it makes sense, right? You have already had an order, so you'll definitely have to mention this is the case number under which this order has been passed, under which the decree has been passed, and this decree, he was not acting on the decree, the other party is not acting on the decree, has not paid me the 10 lakh rupees of compensation which is supposed to pay as per the decree. So that way we will go and plead. So this is what is called as application for execution or execution application, execution petition, EP. It is a very important concept, because even though a judgment or a decree is being passed where you are not getting the money, what good is it for? So EP is very dangerous in terms of the party. You should never be at the receiving end, because let us say you are a company secretary of a company and there has been an order passed wherein you are asked to pay a penalty of, let us say, 30 lakhs because of some non-compliance you did. ROC filed a case against you before the civil court, and civil court passed an order by which you are supposed to make a penalty. So now imagine if the court has ordered you to pay penalty and you actually are not paying it. So then as a company secretary you will be made liable because it is a non-compliance, right? And then the court will, the other authority, the government authority will definitely file for an execution application, in which case the parties individually can also be made liable because of contempt of court. We call it as contempt. Contempt means not adhering to the court rules or the court orders. So where court has ordered you to pay and you fail to make a payment, it would be treated as a contempt, and that would be very severe both for the company and also for the individual. Like on an individual capacity also, you might end up facing some kind of a trouble, right? So that's why never be on the receiving end of this execution petition, right? Let's move forward. Appeals, right? So appeals is one very major concept which you need to understand. So I will try to make it as simple as possible for you. So firstly, appeals from original decree. So what is this original decrees? So before you understand what are original decrees, I will try to explain you this concept of jurisdiction again, which we have covered in lesson number 1. So jurisdiction, in this case, I will only try to divide it into two: original, appellate. So these are the two jurisdictions: original jurisdiction, appellate jurisdiction. So in the original jurisdiction, this is like the origin of the suit. For the first time a suit is being filed, that is, we call it as a suit, right? So I said A and B, there is a dispute. So A filed a suit against B. So that is an original jurisdiction. Not every court will have original jurisdiction. You know, many high courts do not access original jurisdiction. Only few high courts access original jurisdiction. That to the 4 metropolitan ones. I mean, in the sense not metropolitan, but the ones which are there right from the British rule. That is the Chennai, Kolkata, I mean the Madras, the Kolkata, Delhi, Madras. It's not Chennai because that it's still the High Court of Madras because the British have named it so. So the Madras court still has got original jurisdiction. The Calcutta court still has got original jurisdiction. The Bombay court still has got original jurisdiction, and the Delhi High Court has still got original jurisdiction. So these four High Courts, Chennai High Court, Madras High Court, Kolkata High Court, Bombay High Court, and the Delhi High Court, they have got original jurisdictions as well. But if we take example of Telangana, then the High Court of Hyderabad does not have original jurisdiction. It cannot take up a case. If you want to directly file a suit, you cannot go before the High Court. You have to go before the respective civil court only, which has that original jurisdiction. So that is where these cases are called as OS, that is original suit, or OP, which is original petition. So usually in criminal cases we call petition, in civil cases OS, which is suit. So in original suit, the order or the judgment passed and later the decree given is called as original decree. So do not be of the impression that original decree means it's like original certificate we have. The duplicate certificate or the original certificate. So that is not the meaning. Original decree is the decree passed in an original suit, right? That is a decree passed in a plaint, like when a plaint has been filed and then a decree is being passed, that is called as a original decree. So then what happens from the original decree? Now let us take a situation, right? So this way it will be easy for you to understand. So now whenever you have a original decree being passed, so usually it will be either at the district level, since if you remember the hierarchy of courts which we did in the first lesson, it is Supreme Court, High Court, district courts, and then we have lower courts. So this original jurisdiction is exercised only here, district and the lower courts, right? So now where a decree has been passed, so now I hope you understand, decree is being passed in a suit where a plaint is being filed. The end product is the decree, the execution portion, and that decree is called as original decree. So where such decree has been passed, either it will be passed by the district courts or by the lower courts. Let us take first scenario where a lower court has passed a decree. So lower court has passed a decree saying that A shall pay rupees 10 lakhs to B. Now A is aggrieved, saying that why should I pay? I am not allowed to pay. This court did not listen to me properly. So what can A do? A can go on an appeal. So any decree passed, usually there would be one appeal, definitely. There is nothing like from a decree there is no appeal. Any decree passed, there would be a right to appeal. So now from this decree, original decree, this party will go on appeal. But where will they go? They will go to the district court. So district court has got both jurisdiction, which is original as well as appellate. Appellate jurisdiction is where you hear appeals against the orders of the subordinate courts or appeals against the decree of the subordinate court. So in this case, you will go on appeal before the district court. Suppose district court says no, A need not pay, right? So district court says nothing, this court's order is wrong. Now B is an aggrieved party. B wants to go on an appeal. Can he go on an appeal? Yes, he can still go on an appeal from a district court. Then where will he go? He will end up going to a high court, and this appeal is called as second appeals. So second appeals shall always lie before the high court. The first appeal will be before the district court and second appeal shall always lie before the high court. Now I will take a second scenario where the original jurisdiction has been exercised by the district court, right? Let us say there is no lower court, right? Now let us assume the fact that the district court itself has passed an order where A is supposed to pay rupees 10 lakhs to B, and A is aggrieved by that order. Now A wants to go on an appeal. Where will it go? A will go to an appeal before the high court. And isn't it the first appeal? Yes. Now high court has passed an order, and now high court says A is not liable to pay. District court order is wrong. Now B is an aggrieved party. Can B file a second appeal before Supreme Court? The answer is no. You're surprised, right? Why can't I go before the Supreme Court? It's an obvious answer. The answer should be yes. But I did not ask, can B file an appeal before Supreme Court? I particularly asked, can B file a second appeal before the Supreme Court? And the answer is no. Second appeals are exercised only by the high courts. My friends, try to understand this, that in law, every word shall be understood in the same manner of usage which it has got either in the CPC or CRPC. You should not try to mess up with the words. When we say second appeal, it doesn't mean appeal on an appeal. Every appeal on an appeal is a second appeal. There were multiple appeals where you go to Supreme Court. We do not term it as second appeal. It is purely an appeal available against or appeals to the Supreme Court. That is covered under 4, that is appeals to the Supreme Court. That will not come under this second appeal. Second appeal shall always lie before the High Court. So second appeals are from the decree. So from a decree where it goes to the district court, from a district court it goes to the High Court. So that is what is a second appeal, right? You can never say that second appeal is any appeal on an appeal is a second appeal, right? I hope I'm making sense here. So these are the meanings of appeals from original decrees and second appeals, right? Now let us go through appeals from orders. This is quite interesting. And why is it quite interesting? I will tell you. Let us say, okay, now district court, let us say lower court. Now, the point is, the lower court passes judgment decree. This we all know, and this is the finality of the suit. But since we've discussed, if you remember on the previous slides, the interlocutory proceedings, after the filing of the suit and before the disposal, the parties may require certain orders to be passed. So that we call it as interim orders. And these are always termed as orders. They are not termed as judgments, right? So these orders shall be, or rather whenever these orders are passed, these orders can be appealed before the appellate authority. So even before the disposal of the suit, on an interim order, you can go on an appeal before the appellate authority. So that is what is called as appeals from orders. So appeals from orders are a very interesting topic because I'll give you a practical scenario which I have witnessed. So when in a company where I was working, there was an original suit which was filed in 2006. Now, I joined in 2014 there. Okay, in 2020, that is even now, of course, even now the case is still running. That's a different fact. But leaving this part, in 2018. There was an order passed by the Supreme Court. I was interested to see where is the tagging of it. So Supreme Court has passed an order which has come from High Court. When I saw High Court, it has actually come from a district court. When I saw district court, it has come from a lower court on an order passed in OS. So I thought the OS has been disputed, but then because I was not that acquainted with that, I was still a trainee when I joined the company. But later when I understood the entire facts of the case and when I understood the procedure, this is how it happens and all, then when I've gone through the plain, when I've gone through all the documents, I realized that in the original suit, after 1 year, there has been a interim order of injunction against plaintiff. See, injunction has been filed against plaintiff himself. The defendant in this case said plaintiff should not be allowed to enter into the property till this dispute is being settled, and an injunction has been passed. So based on this order, plaintiff filed an appeal before the district court. And in the appeal, the order has been passed in favor of the plaintiff. Now, is there a second appeal on this order? The answer is no. So these orders will have appeals, but after appeals, they will not have second appeals. Hence, since there is no appeal available, so then what do you do? Do you recollect some theories, some concepts which we have done in lesson number 1? So in the absence of appeal, there is one right you have, which is a revision, which you can file before High Court, right? So you can file for a revision before the High Court. So that is what they did. From this court, they filed a revision before the High Court because there is no second appeal from orders. And after the revision has been passed, then High Court has set aside, High Court said the order of the district court is valid. So this defendant again got aggrieved. So now he wanted to go to Supreme Court. How does he go from High Court to Supreme Court? That is what we will see subsequently. I don't want to burden you with too much of theory, but see the flow. If you can understand the flow, even though the original suit is pending, the interim order has been passed by the lower court, then it has been appealed before the district court, then a revision has been filed before the High Court, then he also went on a special leave of appeal, that is SLP we call under Article 136, which we will discuss now. So that has also been filed before the Supreme Court. So this is how the litigation happens in India. Like you have multiple layers of judgments being passed and a lot of time being taken before you come to a final conclusion. Right. Now, coming back to this, so appeals from orders. So sections 104 to 106, they have contained a list of orders from which you can go on an appeal. Only those orders can be appealed. So from there, you have to go to a district court. That's it. There is no second appeal to orders. Second appeal is only on decrees. So remember, decree is a finality. So a second appeal is possible only on a decree before the High Court. Can you go on a second appeal on an order? The answer is no. What can you do? You can go for a revision, because revision can be filed when there is no right to appeal. I hope now you're able to correlate or try to understand the law, the linkage between these two, appeal and revision. Right? Now let us see appeals to the Supreme Court. So from which forum does appeal go to the Supreme Court? It is an obvious answer. It is from High Court. So now I will delete district court and lower court for some time. Now let us say on when does it go to the Supreme Court and how does it go to the Supreme Court? So any appeal filed before the High Court can further be appealed before the Supreme Court, right? So how do we appeal? One thumb rule you should remember is any appeal to Supreme Court shall be only upon certificate of High Court. So for any appeal before the Supreme Court, High Court should give a certificate saying that there is a question of law involved. This is something tricky. So any appeal you make before the Supreme Court, you should also enclose a certificate of the High Court saying that there is a question of law involved in this case. And what are the kinds of appeals you can make before the Supreme Court? Three kinds, right? You can make appeals from civil cases, criminal cases, or constitutional cases. So what are these civil cases? So civil cases are like many disputes, whatever it is. So from there, so where there is a dispute for which there is a question of law involved, then yes, you have to make an appeal before the Supreme Court, for which High Court shall give a certificate. Similarly, coming to criminal courts, the same thing is involved, but it would relate to a crime, right? Next, coming to constitutional cases, it involves something in respect of constitutionality. So question of law dealing with constitutionality of a provision. That should be the opinion made by the High Court, and where High Court says there is a question of law involving the constitutionality of a provision, and that is when an appeal will be made before the Supreme Court on something which deals with constitutionality. Now let us take a scenario where High Court fails to give a certificate, either in civil, criminal, whatever it is. Then what can you do? Is your right to appeal before the Supreme Court infringed? The answer is no. That is where Article 136 will come into picture. So if you observe, Article 132 to 135 are dealing with ordinary appeals. So one article deals with civil cases, one article deals with criminal cases, one article deals with constitutionality cases. But Article 136 is something which is dealing with SLPs, that is special leave petitions. So leave means permission. So where there is no certificate issued by the High Court, or there is a case where a second appeal has been filed and no certificate has been issued by the High Court, then you would like to take it before the Supreme Court at any cost, then that is when you can file a special petition before the Supreme Court asking for a permission. That is special leave petition, special permission to consider my case even without a certificate of the High Court. So that is called as SLP, special leave petition under Article 136, right? So this is what is the appellate jurisdiction. So in criminal cases, the appeals are made to the Supreme Court as we have discussed in Article 134. So the criminal appellate jurisdiction has been conferred in Article 134. So overall, you need to understand the very basic fundamental concept of a decree and from which a second appeal is possible, and the difference between a decree and order. Decree is a finality of a suit, order is during the interim. From the order, appeals are made only before the next appellate authority. If it is district court, from that the appeal will be made before the high court. If it is the lower court, from there the appeal will be made before the district court. But there is no second appeal to order. Second appeal is only for decrees. Then from high court you can go to Supreme Court in three appeals, that is civil appeal, criminal appeal, or constitutionality appeal related to constitutionality. And if in all the three cases you need a certificate from the high court saying that there is a question of law involved. Where the certificate has not been, you failed to get a certificate from high court rejected or refused to give you a certificate, but you still think that Supreme Court should have considered this, then you can still go to Supreme Court under Article 136, which deals with special leave petition, like special jurisdiction of the Supreme Court. So this is about appeals. Now, how is the appeal being structured? It is again the same pattern, like in the page here. Now, which court you're going for? This always comes in the court of, suppose in the Honorable Supreme Court. Let us say we are trying in the Honorable Supreme Court or before the Honorable Supreme Court in SLP number or civil appeal number, whatever be the case, right? Within brackets, against the impugned order passed by High Court of Bombay in some case number so and so of 2020 so and so, dated so and so. So now this is how, like, I give the name of the court, the case number in that court, and also the appeal, the details of this appeal will be given. Then a cost title short, that is the names of the parties, the description, their address of services will be given, and then starting with, so we will have a heading called as Memorandum of Appeal. So this will be the heading. So under the heading, we will, similar to the plaint structure, you remember that. So we'll give a heading. So first heading will be grounds of appeal. So there we will say point number 1, point number 2, point number 3, point number 4. So we will say the appeal has been made. So firstly we will try to explain what happened. We filed a suit before the lower court has passed an order on so and so, then it went on before the district court, when it went on before the high court, then it has fallen before the. So just as like in plaint, we will also try to have the same kind of a structure for an appeal. And after the grounds of appeal have been made, similarly we'll ask what is the relief, then the verification and the list of documents. So this is how an appeal is being drafted. Now the concept of revision. So this is again the same replication what we have studied in the lesson number 1. It is under section 115 where there is no appeal. It will be entertained only by the high courts, and this is purely jurisdiction based. That is where the high court has exercised, where the lower subordinate court has exercised jurisdiction which is not vested in it, or it has failed to exercise the jurisdiction, failed to exercise the jurisdiction, or they have acted within material irregularity. In either of the case, a revision is something which you can file before the high court. So as I given you in the previous case example, where there is no appeal available. So from the orders, there is no second appeal available. So first appeal in district court, you are aggrieved. Then you can file for a revision when you believe that the lower court or the subordinate court has not accessed the jurisdiction which is having, which it has, or it is over exercised the jurisdiction, or it has exercised it with material irregularity and without the exercise of like illegally. So the jurisdiction has been exercised illegally. Right. So now this revision, generally jurisdiction of high court is completely discretionary, number 1, and the aggrieved party where a decree is passed by subordinate court may file a revision. And the limitation period, I mean, these are some facts, like within 90 days you have to file and all. And the structure of a revision is similar to that of an appeal again. So where you will give the revision, but the headings will change, the sections will reference will be changing. Instead of grounds of appeal, it will be grounds of revision, because you are now trying to establish that the jurisdiction point. You have to establish either of these three in your petition. Only then the High Court will entertain your application. Now, so till now we have seen the civil nature of all the suits and all. Now let us go to the complaint. Like there's a criminal nature. Even this I have explained in detail in lesson number 1. So the complaint part, how a complaint will be filed before the police, right? So now there are two kinds of complaints. One is private complaint, one is public complaint, just like companies. The private complaint is something which is made before a magistrate, right? And a public complaint is something which is made before the police. So usually this is called as a complaint and this is called as FIR in general parlance, right? That's why if you see 2D defines complaint as any allegation made orally or in writing to a magistrate with a view to taking action under the code that some person, whether known or unknown, has committed an offense, but it does not include a police report. So any report made by police to a magistrate is not called as complaint, because police never complain. Police will give a report, whereas an individual like us can complain, right? And it's as good as a plaint as you see in a civil case. It is called as complaint in a criminal case, right? Now, it can be oral or written, unlike plaint which has to be written, right? And there has to be certain offense which is punishable under IPC. You have to try to establish that there is an offense which has been committed which is punishable under IPC. You will make it to a magistrate with the object that it has to be taken. So this is what's a complaint. And however, as I told you, this is like most commonly known form of it, that is a private complaint. So a complaint made to the police is called as a public complaint. Okay, so this is the basic you need to know. Now, what is a criminal miscellaneous petition? So similar to your interlocutory proceedings in a civil case, even in criminal case you have something called as criminal miscellaneous petitions, which is not concerning with the main suit. So in a main case, any petition other than a main case is called as a criminal miscellaneous petition. Do not give focus to all these sections. So this is made by my team to make this like a bit comprehensive, but try to understand the provision, right? So any miscellaneous, so the name miscellaneous itself suggests that it is not dealing with the main suit. So usually in a criminal cases, so when you file a petition which is not concerning with the main suit, we call it as a criminal miscellaneous petition, right? And it is registered also as a CMP. And in the same petition, it's just like, as I told you, it's just like a interlocutory proceeding. The court will see whether the relief shall be provided or not. And then if it's so provided, then the petition shall be called in a public court by assigning a number and it will be ordered. Similarly, an interim order also can be passed. A speaking order shall be pronounced, and like there will be various reliefs which they seek before various courts, in various criminal courts particularly. So just remember this, that miscellaneous petition is one which is filed, is a petition which is other than the main petition which is filed before a criminal court. Bails. I think most of you are pretty aware of this concept of bails, because in movies we get to see a lot about bails, right? People go and, a lawyer comes, produces a kind of a document, and the police looks at the document and then says, okay, I release on bail. So what is the document they look at? They look at the order of the magistrate or order of the particular court which passes that bail. So bail is a release of the accused from the custody of the officers of law. So bail is nothing but release of that accused from the custody of the officers of law. You're giving him a bail, right? But does it mean he's released or is acquitted? The answer is no. His responsibility has been entrusted to a private custody of persons who are sureties to produce the accused to answer the charge at the stipulated time or date. See, the very funda of an arrest is to make sure this fellow does not run away, number one. Number two, is available for questioning and investigation as and when they want. That is a custody all about. Arrest or imprisonment is again different. See, imprisonment is a penalty, is a punishment, whereas arrest for custody is for the purpose of getting information from the party and trying to make sure that justice is being served. right? And where you believe that, where an application has been made and it will be said that I am a surety that I will produce this person as and when the police wants them, then the court may consider such application and give an order of bail, right? And usually bails can be given only in bailable offences. Where there are non-bailable offences, there are certain non-bailable offences for which bails cannot be given. For in that case, you can't do anything. You will stay arrested only, right? Then anticipatory bail application. What is an anticipatory bail? So at times where an FIR has been filed against you, FIR we will see on the last slide. So where an FIR has been filed against you, you are of the impression or apprehension that you might be arrested by the police, then you will file for an anticipatory bail even before a police comes and arrests you. So at the time when police comes to arrest you or something, you can produce that anticipatory bail saying that I am on anticipatory bail. If you want any information, I can come and produce before you, but you cannot arrest me. So that is what is the importance of an anticipatory bail application. Usually it will happen in case of this mass gatherings or hurdles, not hurdles, in the sense that agitations made by political leaders, right? So whenever the political leader does any agitation and gathers a lot of people onto the roads, police will usually book an FIR against that person. And as and when an FIR is booked, there is a chance when the agitation is becoming more and more severe, then the law officers will have to make the arrest of that person, because once he is curtailed behind the bars, then the people will slowly get back to their original lifestyles. So that is something which the law officers do, and hence when they come to arrest, then it will be particular. No, you might be sure that okay, he might come and arrest me, so you would file for an anticipatory bail saying that I'm going for a fast unto that so and so, and hence there is a chance that the police would arrest me, kindly give me a anticipatory bail, right? So that is one application, right? Now anticipatory bail, there is one important ruling which you need to know, right? Is that in the case of state of Assam versus R.K. Krishna Kumar, an opportunity of hearing must be given to the opposite party before granting anticipatory bail. So if it is a government case, so a government pleader will be asked like, do you have any objection for me to give an anticipatory bail? And then they might say no. No, if you think so, see, suppose there is a severe criminal who has committed a crime, he goes and asks for anticipatory bail, and if it is like a 10 rupee chocolate that you go give 10 rupee and you get the chocolate, it's not like that, right? It's a procedure of law. So can everything happen that way? The answer is no. So in anticipatory bails, you have to give opportunity to the other party to be heard. So this is the concept of bails, and now let us finally discuss the concept of FIR. So as I told you earlier, FIRs are registered by the police, and the complaint made to the police through FIR is called as a public complaint, and FIR is called as first information report. See the relevance of it. It's the first information report. You go and you are telling it like the first information you're giving it to the police. There need not be any proof. There need not be any evidence. It is just an information which you give. And it is upon the police to deduce the evidence. It's upon the police to deduce or to help you with the investigation, unlike in a civil case. So in a civil case, you should provide all the documents to the court. You should provide all the evidences to the court. You should convince the court. But in a criminal case, the police should convince the court. Otherwise, the police should convince the court against the party. The police should gather evidence. The police should produce the documents before the court. Hence, it is very crucial, right? And particularly, it is cognizable. First information is something which the police can have, right? It gives a cognizable crime, that is a crime which should fall under IPC, which is very important, right? And what is the object of an FIR? The object of an FIR is that, see, there are various views of it. So if you look at it from the point of view of the complainant, it is to set the criminal law in motion, that is to get justice being done. If in view of the investigating authority is nothing but the police. In view of them, it is to obtain information about the alleged criminal activity, right? Because I know, like, he is telling something about the crime. The information I'm getting is through FIR. So from the point of view of an investigating authority, this is a document which gives me information about the alleged criminal activity. Then it is also, to record the facts and circumstances before it is forgotten by the informant. So there is a chance that you might miss minute details. So FIR will help register all that. And from the point of view of the accused, so accused is that person who has been accused of a crime, right? In the sense that who has been blamed for a crime. So from his point of view, the object is to safeguard the accused against subsequent additions and variations. So suppose if there are some information not given in the FIR, later they try to change the words, right? So that is something which can protect the accused at times. And from the court's point of view, so from the point of view of court, if you see, it is to make known to the court where the case is going to be tried. So you will describe the offense, you will describe where the offense has taken place, the place of offense. So according to that, the court will decide like where the case will be tried, that is, does it have jurisdiction or not. So even that can be seen through an FIR. These are various objects of it, right? So before I conclude, let me give you a very interesting perspective of an FIR in the terms, because like I personally had an experience in working under a police officer on a particular assignment. So over there I have learned how these things work, right? So firstly, you file a complaint through an FIR. In an FIR, an investigation officer will be assigned. This investigation officer will do investigation, for which he will take statements of various witnesses, peoples, and then he will collect several documents. He will collect evidences, then he will do forensics, take the reports thereof, and he will compile everything. He will update something called as case diary. Every day you have to upload where did you go, whom did you meet, what was the statement being made. It has to be done like on a sequential basis. And after the entire case diary is made and also investigation has been done, statements have been collected, evidences have been collected, and all this has happened, then they will make a report which is called as a final report, which will be submitted to the head of the police there, an ACP or someone of that cadre, depending upon where the case has come. And after the final report is done, this report will be submitted to the magistrate. That's why this report to magistrate is not called as complaint. Complaint is something which is made to the police, or complaint which is made directly to the magistrate. But the report made to the magistrate is not called as a complaint. It is called a report only. Accordingly, the magistrate will look into it. So from there, what we have seen in the first case, in the first lesson, that is warrant case or a summary case, accordingly they will do the trial. So this is what is the procedure part, right? So with this, we have finished the discussion on pleadings, right? So in case you have any questions on anything in the pleadings, you can leave the questions in the comments column. And we wish to state that from July 1st week, we are launching a paid course on drafting. So that course will be more detailed, wherein we will cover each and every topic in further detail, and where the drafts will be covered in detail. I will explain how the clauses have to be drafted, how the draft will have to be shaped. Then I will give exercises to the students to answer. I will take their answers and give my personal feedback on each and every answer they make. So every lesson will be recorded, and then there would be exam preparation tips for each lesson separately from me, from my own experience. And then each lesson will be followed by quiz by various questions, and then an assignment where I will give you certain questions to answer on your own, and you give me back for my feedback. And then subsequently, after all the lessons have been done, there will be 3 mock tests. And after the mock test, which I obviously will correct, then there would be one-on-one sessions where I will clarify the doubts of students, and there would be weekly live sessions depending upon the number of doubts raised by the students. And finally, there would be an exam preparatory timetable which I'll give for the subject exclusively, right? So this is something which is a paid course, right? You treat this as an advertisement or a kind of an information, right? Because it's a kind of time for us to take it off from here. Thank you so much for all the support. Of course, I'm going to complete the entire syllabus of the drafting on the YouTube platform. There are 2 more lessons left. I will upload it very soon, but it's just my word that if you can communicate this, because now that you have heard me teaching all these lessons, you know the worth of or rather the kind of research we put in before we teach. And this I try to make it so summarized, because this is purely intended for you to take a quick revision before the exams. But for some, it might be difficult to understand so much, right, on a very short period of time. So hence my course will be purely detailed, and it will really help students gain proper practical knowledge on drafting, and it will not just help you for your exams. I give you my word, it will help even for your profession, right? And now, if you are interested in that course, there is a form below. You can fill the form, right? Thank you so much. Bye-bye.